Professor David Southall had form. In 2004, he was found guilty and suspended from undertaking child protection for 3 years after he accused the husband of jailed solicitor, the late Sally Clark, of murdering their children after Southall watched a documentary about the case. This time he made a false accusation that a woman drugged and killed her 10-year-old son. The GMC today claimed that David Southall had deep-seated attitudinal problems. But the Royal College of Paediatrics and Child Health, which has always backed David Southall, issued a statement regretting today's decision. John Sweeney, who covered the case of Sally Clark and other miscarriages of justice, reports.
Professor David Southall, pioneering paediatrician, unjustly demonised for doing his job, the victim of a witch hunt. Or a modern-day witch-finder general who accused innocent parents of murdering their children with unseemly regularity. Today, the General Medical Council came down against him and struck him off the medical register. Chairwoman Dr Jacqueline Mitten said,
"The panel has concluded that you have deep-seated attitudinal problems and that your misconduct is so serious that it is fundamentally incompatible with your continuing to be a registered medical practitioner. The panel is particularly concerned by your lack of insight into the multiplicity of your failings over a long period."
Southall intends to appeal.
In common with all doctors who work in child protection, I've often had to make difficult and sometimes unpopular decisions, but the welfare of the children has always been paramount in my mind.
Southall's supporters are deeply dismayed. They fear that the job of child protection will become nigh on impossible.
There has certainly been a very intense and active campaign over the last 10-15 years which have put out a whole variety of stories, most of which are really completely separate from the truth.
Professor Southall, when you've done it again?
There are few more difficult judgments in modern society than deciding whether a parent is fit to look after their own children. Southall lost his ticket because he made the same mistake twice. He falsely accused Steve Clark, the husband of wrongly convicted cot-deaf mother Sally Clark. Southall had watched Mr Clark on the TV and phoned up the police and told them that he was the real murderer. Steve Clark had to fight hard to clear his name and that of his wife. Sally Clark died this year, a broken woman. Then Southall falsely accused Shropshire mum Mandy Morris of drugging and murdering her 10-year-old son Lee. He'd hanged himself in 1996. But that's not the end of it. Southall frequently gave evidence in the closed family courts, where people can lose their children in forced adoptions. He accused Janet Alexander of faking illness in her son, Lawrence.
They knew what was actually wrong with me, and yet they wrote all this child abuse stuff anyway. You know, for some strange reason, they decided to accuse Mum and Dad of causing these cot-deaf episodes by like, suffocating me or something, rather than actually confront what was really going on.
Southall was a genuine pioneer, with a new technique of nailing child abusers, covert video surveillance, like these images from the United States. But critics said it wrongly accused at least some innocent parents of abuse. Even more controversial was Southall's attempts to recreate the circumstances of smothering by reducing oxygen supply to infants. Some say that in trying to prove child abuse, he ended up harming children himself. A decade ago, Southall and his mentor, Professor Sir Roy Meadow, were in their pomp. The power their expertise held over judges and juries was immense, but then their world began to fall apart. First, Sir Roy Meadow was disgraced after giving false evidence in 3 cot-deaf trials. Next, it was the turn of David Southall's work to fail under scrutiny. Today's ruling doesn't close up the chasm between the two groups. One side sees heroes saving children from abuse, the other almighty paediatricians ruining lives. The enemies of David Southall will say the difference was that he was in a position of power over them, and he exercised it with reckless fanaticism.
John Sweeney. Well, I'm joined now by John Batt, who was one of Sally Clark's solicitors, and by the Liberal Democrat MP Evan Harris. Gentlemen, this is such a polarised case. John Batt, how do you account for the fact that David Southall has the support of his professional body?
Because they have supported every member of their own profession who has been charged with serious professional misconduct. And I think this is because they're taking a blinkered view of what is actually going on.
Evan Harris, today you called today's verdict a serious miscarriage of justice.
Yes, firstly,
Why?
I call the report we've just seen extremely biased, making allegations about Sir Roy Meadow, who was actually cleared of serious professional misconduct in the High Court in the Clark case, and indeed his erasure verdict by the GMC was crushed. Now, John Sweeney for some reason doesn't say that, and he says that when people get something wrong, it's a false allegation. Okay, if I say that's biased and you say no it isn't, and you turn out to be right, I'm not making I'm not using bad faith.
No, you're not.
So there's good faith involved here, and even the GMC said today, if I could just make this point, that David Southall was motivated by an attempt to help children. That shows good faith, not bad faith, and the allegations that it's a deliberately false allegation suggest it's bad faith.
Well, let's just take one very high-profile case here. That he, in his expert judgment, having watched a television programme, made an accusation that Sally Clark's husband was responsible for the deaths of a child. Now, by any standards, you would say, as a doctor yourself, that was extraordinary.
Well, I wouldn't comment on that without having heard all the facts, and I didn't sit throughout the hearing, so I know there's a judgment there. I want to make the point that there is a campaign going on against paediatricians by some people who don't believe there is such a thing as parentally caused fabricated illness. I don't know if John Batch thinks that Munchausen syndrome by proxy does exist or not.
No, it clearly doesn't
Right.
exist.
Well, the medical
Court of Appeal in Australia, three very learned judges said it simply does not exist.
And the reason that's why there's that dichotomy, because the medical establishment, as he calls it, that is scientists looking at the literature, believe it does exist. His campaign group, and obviously Mr. Batch is employed as a lawyer by people who want to fight this case, argue it doesn't. Now, people who harm their children, and there are lots of, sadly, of parents who harm their children, will always, in many cases, claim they're innocent.
I don't deny that for one moment, and I applaud the role of paediatricians in child protection. This is not what the argument is all about. The Victoria Climbié case, where there were over 150 inflicted injuries, are obvious cases where paediatricians have a role to play in protecting children from the predations of adults. But I personally know of 13 cases where false allegations have led to people being tried in court, to years of torment, and they're all based on expert evidence.
Do you accept there's a difference between accusations that are made in good faith to protect children that turn out to be incorrect, and this sort of thing is not perfect, and false?
But how do you decide? I mean, the problem for any
false is a loaded
parents,
term, and your journalists use that in the
well,
report.
let's change for a second to talk about how expert witnesses are perceived. First of all, it's their utter certainty in a court which makes them attractive to the case, because they then can say to the jury, well, I, in my professional understanding, believe such and such to be the truth. The very problem that poses is one that, how do you discredit them?
This has been looked at a great deal because it's not straightforward, but we have to remember that in the court are experienced lawyers who are capable of challenging the evidence, capable of bringing an alternative expert witness. In the new procedures, there's a drive to ensure that experts agree beforehand so that the court, the judge, or in the case of criminal cases, the jury isn't trying to weigh up.
If they make arrogant and sweeping judgments, as is often the case,
Would you say it's often the case? Well, there are a number of highlighted cases. There's no doubt that Roy Meadow was wrong to make the assertion that he did. The High Court, in clearing him of serious professional misconduct and the striking off, said that that was a mistake. It was made in good faith. But you're claiming now that it often happens. Actually, in the vast majority of cases, paediatricians bravely come forward in the face of an orchestrated campaign against them to do this difficult and fraught work.
How do you reform our approach towards expert witnesses? How do you make sure that expert witnesses are given their due place but not given too much
Well, we've got a basic problem with cases like this, because for a doctor to accuse a mother of killing her baby is one of the most repellent and disgusting accusations that can be made.
But it happens.
Oh, certainly it happens. The Victoria Climbié cases happen. All of the cases with which I have been associated involve parents where there has never been a breath of a suspicion of anything except that they are loving parents. Now, it is those cases which go wrong where you cannot get a jury verdict of not guilty because they always believe the doctors, and the doctors are getting it wrong.
Thank you both very much.
It's a difficult area.